Are we ready to proceed? Okay. Good afternoon and welcome to this online hearing of the Committee of Adjustment for the City of Ottawa. The Committee of Adjustment is a quasi-judicial tribunal appointed by City Council to make decisions on certain types of applications under the Planning Act. My name is John Blatherwick and I will be chairing this hearing today. With me are my fellow panel members, Bonnie Oak Charon, Stan Wilder, Heather McLean, and Michael Wildman. Please take note that this video conference is being live streamed on YouTube. The video will be archived along with today's agenda on the city's website. Before we begin, we have a few items to outline for your information. While the issues surrounding development in the city are broad, our mandate is quite limited. The committee cannot consider aspects of the proposal that are not related to the required variances: noise, pollution, property maintenance, property values, prosecution for illegal construction, personal comments regarding neighbors, agents, or applicants, additional variances without proper public notice. If there is an identified need for an additional variance or variances, including an increase in the extent of the relief required, a recirculation of the application is required. As part of the statutory public notification requirements, each applicant was required to post a sign on the property and file a statutory declaration confirming the sign posting. We have only received one of those to date, so I'll be administering an oath to each of the applicants for the rest of the applications on the agenda. Regarding quorum, if this is lost during the hearing due to technical difficulties, the proceedings will be paused to allow time for the resolution of the issue. Failing the ability to reinstate quorum, hearing of the items remaining will resume at the outset of the next regularly scheduled meeting of the committee. In terms of the hearing process, listed on the agenda and appearing on the screen are the applications we will hear today. For the sake of efficiency, the committee may deal with agenda items in a different order. Note that the committee members have reviewed the application materials prior to the hearing and any written submissions received in support or in opposition. In addition, the committee will hear today oral submissions from any interested parties as part of our proceedings. The committee may ask for a brief presentation by the applicant, followed by questions from members where clarification may be needed. The public submissions portion of the hearing will then begin, and any interested parties will be invited to make their submissions to the committee. Panel members may then ask follow-up questions where added clarification may be required. When you are called upon to provide your comments, we will ask you to do the following. Start with stating your name and municipal address for the record. We may ask you to spell your name. Then begin your submission by addressing your comments to the panel members. You may ask questions, but please direct them only to the chair. Please limit your comments to a maximum of 5 minutes. Any exceptions will be at the committee's discretion. Once all interested parties have had an opportunity to address the panel, the public submissions portion of the hearing will then be closed. The committee will then make an oral decision to either grant or deny the application. The committee may also choose to reserve its decision. In such case, the panel will deliberate further on the evidence presented immediately following adjournment of the public hearing. In either case, the committee will send within 10 days of its decision, and to all parties and those who have requested it, a written decision that sets out the reasons for the decision. All decisions of the committee are subject to a 20-day appeal period, during which the decision can be appealed to the local planning appeal tribunal for a fee. Before we begin, are there any declarations of interest from any of the members regarding items on this agenda or the agenda of panels 2 or 3? Seeing none, fine. We have a confirmation of minutes, and we need and these have been circulated to the members. These are the minutes from June 3rd, June 17th, July 8th, and July 22nd of this year. So, in the matter of the 3rd of June minutes, all in approval of the decisions. Any changes needed? No. All in approval? Okay, fine. June 17th, approved. The minutes approved. Approved. July the 8th, are the minutes approved? They are approved. And July 22nd of this year, the minutes approved. Fine. Thank you very much. Now go, before we get on to the main agenda, to adjournment requests. And today we have on this agenda one item that is up for adjournment. That's item number 9, 7 Rosedale. And I believe it's Mr. Benas who is requesting the adjournment. And I also believe that the planning department has requested an adjournment on this application. Mr. Benas, are you there?
Yes, I am. I tried to unmute. Can you hear me?
Yes, we can.
Okay, perfect.
The reason for your request for adjournment?
We need a legal opinion about the ability to construct above a right-of-way.
Okay. All right. And the planning department is in agreement with the adjournment, I take it?
We are, yes, for the same reasons.
Okay. All right. Any questions from the members regarding the adjournment? No. Mr. Benas, since you're going to be seeking a legal opinion on building above a right-of-way, we are going to adjourn this application sine die, which gives you adequate time to resolve your issue.
Okay. I'm not sure I know what sine die means. Sorry.
It means it's adjourned until you reapply and a recirculation has to take place.
Okay.
Because that's probably the best way. I don't think you can resolve this within 2 weeks.
No, I don't think so.
Okay. So all in favor of adjourning this application, sine die? All right. The application is adjourned. Thank you very much.
Thank you.
Next, we will now move to the main part of the agenda. Goes away here. Right. We'll deal with item number 1, which is 863 Maitland Avenue, and we do have a statutory declaration for this application. This is a consent to subdivide the property into 2 separate parcels of land in order to create separate ownerships for each existing semi-detached dwelling. The application indicates that these lots were previously separate lots and have since merged on title. And I believe Mr. McLean is the applicant agent on this.
That's correct. Can you hear me?
Can you give it? Yep. Could you give us your address, please, Mr. McLean?
The subject property address is 861 and 863 Maitland Avenue.
And your address?
1073 Wellington Street, West, Ottawa.
Okay. All right. If you could just very, very briefly explain what you've been going through. I noticed that you don't have to, the fire separation compliance issue has been resolved.
That's correct. Yes. I believe all the various parties, there was very few comments. There was one that we'll have to deal with, obviously through hydro.
Okay.
That'll be the main issue. As you're aware, the properties merged when the numbered company purchased the property back in 2017, and we're looking to undo that.
Okay. So you're still in ongoing discussions with hydro?
Yes, I've spoke to someone there. We're going through the formal procedures to be able to meet their needs. Basically, there's one of the properties, the adjacent property 863's hydro service line crosses a portion of 861. So we're
Okay.
looking to remedy that. Yeah.
And the other conditions from the planning department were the confirmation of independent services, joint use and maintenance agreement, and a noise level agreement as well.
Yeah, we're okay with that, producing those. That won't be a problem.
All right. Any questions from the members on this application? All in favor of granting this consent as applied for?
Mr. Chair, I might add that we might want to add a party wall certification on that as well.
Oh, yes. Thank you, Ms. McLean. Yeah, Mr. McLean, we're going to add a condition requiring party wall certification.
Okay.
All right. All right. So with that amendment, all in favor of the consent application? Your consent's approved. Thank you, Mr. McLean.
Okay. Thank you.
Next application we had dealt with is item 2 on the agenda, 268 Carruthers Avenue. And this is a consent, a lot line adjustment to convey a portion of the rear of the property to the abutting landowner to the west, known municipally as 177-179 Armstrong Street. And I believe Mr. Holzman is the agent for the applicant.
Yes, can you hear me?
Yep. Can you give us your address, please, Mr. Holzman?
Our mailing address is 43 Village Walk Private, Manotick, K4M1L1.
Okay. All right. If you could give us a presentation on your request, please.
Okay, I'm going to be running through a brief presentation. I submitted exhibits that were either part of the original application or subsequently yesterday and this morning, a couple of photos. So if we could bring up the Carruthers survey plan, please.
First of all, I've got to run you through the oath of solemn declaration.
Yes, sir.
Do you solemnly swear and affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
Yes, I do.
Okay, please proceed.
Okay, so there's, well, that's the draft reference plan. We could actually use that. So the Carruthers property is a rectangular piece. Actually, I think you better put up the Carruthers survey plan as well, the first, because it makes it much simpler. If you could, coordinator. There you go. Well, that's the draft reference plan shown. So what's marked in orange and yellow is the subject property. You can see that the property fronts on Carruthers, which is on the right-hand side of that draft R plan. The retained piece is shown in yellow. It would have frontage at 10.06 on Carruthers, which it has today. And then the back piece in orange, noted as severance, would be, if successful, added to property known municipally as 177-179 Armstrong. It's an odd-shaped property, and I'll get to that. If we could show, move forward to the reference plan or the survey plan for Armstrong, please. Well, you can see it there in blue. So that's actually the block map, but that's fine. Okay, so I'll just continue on then. The site is presently zoned R4H, which allows for a number of uses, including a detached dwelling. The intention of this application is to sever, as you can see there, the rear portion of the property of Carruthers and add it to the abutting odd-shaped parcel known as 177-179 Armstrong. If successful, the enlarged property at 177-179, including the rear of 268, is presently the subject of an application for site plan control. That application was filed on June the 4th of 2020. Now, an application for both the combined Armstrong property and the retained parcel here is also the subject of an ongoing zoning bylaw amendment application. It was also filed the same time in June 4th. The city has provided us with the initial round of comments, and there's no significant changes to that site plan application as a result of the comments. A virtual community information meeting was held on July 30th under the direction of the ward councillor. It was very well attended with over 50 participants, and the intention of this particular consent application was discussed at that virtual meeting. The approval of the consent that we're asking for today, a lot line adjustment, would assist in part in regularizing the development, the receiving parcel. As you can see from the site plan, could you bring up the site plan, please?
I'm sorry, we did not receive a site plan as part of a presentation.
Well, it was submitted with the original application. Well, on the site plan, you can see, or you would see if it's in your file, that the addition to the severed parcel would still allow for about 170 square meter gross floor area of a single detached dwelling on this retained parcel. It would be a 3-story building, just like the current structure's 2.5 stories. Could you pull up the lotting plan, please? You had it there. You had it there already. Okay, you just skip by it, please. Okay, there you go. So you can see that the retained parcel is the one that's address 268. You can see from that there are many similar depth lots that are in the existing neighborhood. It's a very eclectic mix of lot sizes, shapes, unit types. And in fact, there are a number of lots that are actually smaller that contain 3 to 5 dwelling units. And again, the purpose here is to sever off the back to add to a development application, but to keep a retained parcel that would meet all of the R4H zoning provisions, except for minimum lot area. And again, that's part of an application for zoning bylaw amendment that's currently ongoing. Now, we circulated as well as part of this application 45 hand-delivered notes to all the abutting neighbors. We've heard from no one other than the Hindenburg Community Association, which we've had a dialogue with them for the past year or so on this, including pre-consultations for the other development applications. They raise a number of concerns, and I'll just go through them very, very briefly. First of all, they're talking about this as the need for providing parking on the receiving piece of property as part of that development. That has nothing to do with this application. That's the subject of another application. We're dealing with that comment and their concern with regards to that. They also state that this retained parcel would not meet the amenity area requirements under the R4H and mature neighborhood overlay. Well, that's not true. There is no amenity requirement specifically for a single detached dwelling. You satisfy that through the provision of a rear yard. And again, we've suggested on the site plan that we would meet all of those performance standards. Third, they're suggesting it's premature until the site plan and the zoning is dealt with. Well, the city has always taken the position that when you're establishing a lot line that deals with zoning, you need to know where that lot line is conditionally by the Committee of Adjustment. Just to gather my thoughts. Finally, we've reviewed the staff report. We concur with the conditions. They adequately deal with all of the issues that could be raised. And we obviously concur with their recommendation, and we ask for conditional approval today. That's my presentation. I'm here for questions and answers if you have any.
Thank you, Mr. Holzman. Could we hear from the planning department, please, on this application regarding the conditions that you'd like to have imposed? I'm assuming the department is well, I know the department's in approval, so.
Certainly, Mr. Chair. So the department has no concerns with the conditional lot line adjustment. The conditions that we're imposing are registration of the parcel of land through the Committee of Adjustment, proof that the zoning bylaw amendment has been approved and that all the appeals have been exhausted, as well as given that there's a proposal of a new single detached dwelling on the retained parcel, we would ask for a demolition proof of the dwelling as well as the existing shed, a servicing plan, and a grading and drainage plan.
Okay. And also, you're talking in here on our cheat sheet, it says party wall fire separation. Is that still valid? I don't believe it is. So we'll eliminate that. Okay.
That may be for the previous application that member McLean raised.
Yeah. All right. Okay. So the lot that will be created, the retained lot, it is a substandard lot according to the performance standards of the R4H zone.
Are
you asking of me, Chair?
I'm asking planning.
That is correct. The zoning requires a lot area of 270 square meters.
Yeah.
The lot, I believe, it'd be 143 or so square meters. Therefore, the zoning bylaw amendment, it's in place to deal with that requirement.
Okay. And as far as lot width, that's fine.
Yes, that is correct. The lot width is met.
Okay. All right. Any questions from members on this so far? Okay. We also have several other people on the speakers list. We have Ms. Hode from the Hindenburg Community Association. Ms. Hode. Can't hear you, Ms. Hode. You're muted.
Okay, I'm never
Okay,
sure
so-
who does the unmuting.
Yeah. So your address, please, for the record.
Yes, my address is Unit 509, 1000 Wellington Street West.
Okay. So briefly, please, Ms. Hode, the community association's concerns with this application.
Yes, I wonder if you could show the site plan for the 177, 179 Armstrong proposal, which I did submit. So I think you'll get a better sense of what's happening. No, it's the site plan, which shows the new building to be constructed and the layout with the parking and driveway.
We may not have it. You never know.
I sent it.
And I submitted it with the original application.
Well, you had to do it by Monday, 4 o'clock.
Correct.
Or was that noon? I can't remember. A lot of deadlines.
Yeah.
Just one moment, Mr. Chair. We are getting it up.
Okay. Thank you.
There we go.
Thank you.
All right.
So you can see on the left-hand side, the lot that was to be retained at the, which is backing onto a driveway, which services the new development, 33 units, and 7 rear yard parking spaces. And you can see that almost the entire rear yard is covered with parking, asphalt or whatever is necessary to allow the aisles to work, and a driveway. Our concern is that this is not an appropriate development, nor is it necessary to provide 7 parking spaces for this new development. And I would like to explain to you how the lots got created on the on Carruthers. It is an interesting.
Realize we're dealing with a consent application for.
I do, and our contention is.
And we're not dealing with the specifics of the site plan because that is before the city.
Yeah, our contention is that this severance is unnecessary because the parking is unnecessary. The applicant has several opportunities to do this development. He can provide no parking, which is permitted, or we had proposed actually 2 parking spots in the side yard, 1 car share, 1 visitor. He could reduce the size of his building so that he doesn't have to put parking across the entire rear lot. Or he could put the parking underground. So the severance is unnecessary to facilitate the development of the adjoining lot, which we realize you are not responsible for. I wonder if you could show the next submission I made, which is a sketch of the lot. Yeah, the history of this area is a little odd. The village of Hintonburg took a chunk off lot 5, the lower lot, and the owner at the early 1900s then created out of lot 5 and the south half of lot 6, 2 lots perpendicular to Armstrong Avenue, as opposed to the rest of Carruthers where the lots run east-west. You can see that 268 is on the north half of lot 6. There was a house on the east half of lot 5 facing Armstrong Avenue. It burned. I think early late 1990s, yes. Early 2000 possibly. 276 Armstrong, which you can, 276 Carruthers, which you can see on this particular plan. And if you could show the photograph, it was attached to the building that was built on Armstrong Avenue. You can see it there. And that's 177 or 179 Armstrong. It was attached, the building at the front facing Armstrong burned. this building, which had been attached to the original building, remains. When someone acquired the parking lot, illegal, and then proceeded to develop the 2 townhouses, which now face Armstrong Avenue on small lots, we did not object to that. We don't object necessarily to small lots, but we do expect small lots to create new residential dwellings. And that's not what's been happening or not going to happen here. So that is, I think, our major objection. It's not that the lot is necessarily small, it's the purpose for doing the severance. If this severance would result in another unit, we probably wouldn't object, but it's not going to result in another unit. It's going to result in a driveway leading to a large parking lot. The applicants mentioned to me that they heard from neighbors about the problem of parking. We don't have enough parking. Where are people going to park? As I'm sure you know, and we certainly hear this every time there is an infill development, parking. The city's policy, which we support, is to reduce the dependence on the automobile, and to promote walking, cycling, and transit, particularly here, which is practically at the Tunney's Pasture light rail station. You can see the Tunney's Pasture building in the background. So that's basically our position. This is not an appropriate severance, and we request that you refuse it. Thank you.
Thank you, Ms. Hood. Any questions of the presenter from the members of the committee? No? Okay. We also have Ms. Dozois, who wishes to speak. You're muted, Ms. Dozois.
Hear me now?
Yeah. Could I have your address, please?
Yes, I live at 329 Hinchy, unit number 1. I own the triplex here at 329 Hinchy and live on the first floor.
Please. What are your concerns or comments regarding this?
I have a prepared statement. I'm not as good as Linda is at this, so I'll be reading my statement. Let me begin by stating that I, a neighbor to the back of this property, am opposed to this proposed consent that will, number 1, remove all the rear ground level amenity space from 268 Crothers, and 2, convey it to the property at 177, 179 Armstrong for the sole purpose of providing a driveway to the proposed parking lot. My property abuts the rear of 177 to 179 Armstrong, where the proposed parking lot will be. As a background to the decision to this decision on my part, I have to tell you that I participated in consultations on many development proposals over the years and have recently followed city consultation on the infill bylaws and the R4 changes. All of these consultations that I attended have stressed the importance of preserving green space, space adequate for tree planting, reducing or eliminating parking, and in the last 2 years, the parking only be allowed when all the green space requirements have been met. This request for conveyance is the opposite of all proposals city staff have been talking to us over the last couple of years. And why is this? Number 1, a 14.29 meter lot depth is not consistent with the lot pattern in this community or on this street. The majority of the lot depths are 30 meters with some 28 to 29 meters. Number 2, dividing this lot in half to provide parking for a neighboring development is not keeping with any of the new R4 zoning principles that the city staff have been working with us to implement. In most cases, parking is prohibited in an effort to provide and protect green space and trees. Taking away 50% of the lot to provide a driveway to a parking lot is not keeping with the city's policy. And the infill guidelines for properties less than 23.5 meters require a rear depth of 25% of the lot. This does not seem feasible on a lot that will only be 14.29 meters. For the committee, may I reiterate that in the directions to staff that our councillor, Jeff Leeper, noted on the new R4 in September of 2020, that the staff was to apply the quote unquote landscaping first approach that's described in the new infill rules to the rear yards as well. In addition, the proposal does not meet the 4 tests under the Planning Act. Number 1, a 50% reduction in the lot and no rear yard is not minor. Number 2, it is not appropriate nor a desirable development for this street, area, or community. Number 3, it is certainly not in keeping with the purpose and intent of the zoning bylaw, neither the infill bylaws or the R4 bylaw. And number 4, I do not feel it is in keeping with the purpose and intent of the official plan. The days of paving everything over to provide parking have been gone now for many years. I have one last point to raise this afternoon, and it has come to my attention and my neighbors as well that have attended some of the consultation, that there's a feeling on the behalf of developers and possibly city staff that many in Hintonburg are opposed to new buildings that have no parking. And this is the feeling why that this feeling is a reason why severing this property for a paved parking lot for 7 spaces should be allowed. Let me clearly state that this is not true. Yes, there is a voiced concern that almost every single consultation that we have been involved in the last month has raised the issue of no parking spaces for each development. But the discussion focus has been mostly on the fact that there has not been any allotment on all of the developments for 1 car sharing space and or a visitor spot, a car share that could be used for all tenants per building. We have not been asking for regular parking lots. We do not believe in the paving of an entire backyard for parking. We do not believe that each development demands a parking lot. Myself, I've lived for close to 20 years now without a car. We believe in intensification, especially near transit stations as this development is. And lastly, we are most concerned with our tree canopy and that trees and backyard amenities are needed on this backyard space, not paved parking. So I hope you will reject this application, and I ask the proponents to rework their plan. I and my neighbors along Hinchy and Armstrong and Crothers, along with the HCA, would be delighted to participate. Thank you very much.
Thank you, Mr. Wolf. Mr. Holzman, you've heard from the Hintonburg Community Association and a local resident. Would you like to reply?
Yes, I have 4 quick points in addressing their comments. First of all, the site plan control application is still ongoing. We received a number of comments, including the viability and the need for those 7 spaces. Our initial feeling was for a 33-unit building, 7 spaces was reasonable. We're certainly considering that in the scope of that application. Second of all, this is not an application for a minor variance, so the 4 tests don't apply. Third, the Committee of Adjustment is given the authority to consider whether a consent is the appropriate method to subdivide land as opposed to an application for subdivision, and we put it to you and in our covering letter of September 15th that this is the appropriate manner to which it should be dealt with. And fourth is, it doesn't matter how the lots in the neighborhood were created, they exist. There are 12 to 14 examples of lots that are shallower than the standard lot. And as I indicated earlier, this particular lot, whether it ends up being redeveloped for a single detached dwelling or something else, will meet the performance standards other than the minimum lot area. We've shown that on the site plan, and that'll be subject to the zoning bylaw amendment. So those are our comments in response to the community's concerns.
Thank you, Mr. Holzman. Any comments from the panel, Mr. Wilder? You're muted, Mr. Wilder.
Yeah. Mr. Holzman, 2 questions. The conveyance, without this conveyance from the lot, looking at the site plan, the drive, which is to go to the rear of the property to provide that asphalt, to provide those parking spaces, would not be plausible. Is that correct?
Well, that's correct, but I can tell you, sir, through the chair, that we have looked at a number of alternative layouts for this particular property, and the one that we felt matched and worked with all of the issues was the layout that we have proposed. But as I indicated, this is subject to a site plan control application, and there's always opportunities for some revisions as we consider all of the comments.
I understand that. I guess my second question goes back to, I understand that, you know, in terms of, one would say taking the cart before the horse in terms of dealing with this application prior to the site plan application. Seeing there's going to be a number of modifications to this site plan, as you just mentioned, looking at different alternatives. I'm not sure when that site plan is not separate from the zoning, but when the site, I guess they'll be taken together, the site plan and the zoning application at some future point. Is it premature, is I guess a question, to deal with this consent application, whether we support it or not, but is it premature? You're saying it's not premature. I guess that's a question which we have to deal with.
Can I respond to that?
Yes, go ahead.
Yes, well, the city needs to know where the lot line is conditionally located so they can prepare a proper presentation and report with recommendations to your planning committee. And this has been the past practice to deal with a consent, and if conditional approval is granted, there's a year to satisfy the conditions, including the rezoning. Your planning department have indicated that to you already.
Thank you for that.
You're welcome.
Any other questions or comments from the panel? All right, I think that probably the best course of action for us to take today on this is to reserve, given what we've heard from the applicant and the local community association and a concerned neighbor, and the input from the planning department. So all in favor of reserving on this application? All right, so we'll reserve on this application, and you will have our decision in 10 days. Thank you very much.
Okay, thank you very much. Bye-bye. Next application on the agenda is item number 3, 146 4th Avenue. And this is a minor variance to permit a reduced westerly side yard setback in order to regularize the existing triplex on the property. And I believe the agent for the applicant on this is a Miss Birdie. Is she there?
Yes, I am here.
Okay, and I'm going to have to administer the solemn oath before we begin.
Yes, that's
Do you
correct.
solemnly swear and or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
Yes, that's correct.
Okay. So this is an application to regularize an existing triplex. And before you start, Miss Birdie, if I could hear from the planning department on this application, please.
Through you, Mr. Chair, that it's correct. The variance here requested to reduce the side yard setback is to recognize and regularize that triplex that it appears to have been functioning as a triplex for quite a long time.
Any idea how long it's been functioning as a triplex?
50 years.
So this was an illegal conversion to a 3-unit dwelling, I'm assuming.
I can't speak whether or not when that happened, but it appears that at some point that the duplex was converted into a triplex, and recently it was come to light, and therefore we are here in this process.
And by approving this, we create a legal triplex on this site.
That's correct.
Okay. All right. Thank you. Ms. Birdie, very briefly, please.
Yes,
I don't need
of
all the
course.
we don't need all the background on this. We've read your letter.
That's fine, thank you. So I'm requesting a minor variance for the reduced side yard setback. The property was built as a duplex around 1902 to 1917. It has been in existence as a triplex for about 50 years. I purchased the home in 2002 as a 3-unit dwelling. I realize that the home is listed as a duplex with the city, and I am hoping to formalize this existing triplex. There are no alterations being made to the interior or exterior of the building as part of this application.
You've indicated in your letter that you're paying taxes based on a triplex?
I have been since 2002, yes.
Sounds to me like two city departments need to get their information straight.
Well, I also, at the time of purchase, had received was presented with a zoning document by the seller dated April 11th, 2001, which stated that the use complies with a 3-unit converted dwelling, stated that the dwelling was exempt from any development charges for the 3rd unit, for that additional unit. It included a plan from the planning branch that was approved by City Council in 2000. All of my property assessment notices say triplex. And I, at the time of purchase, had the deed states that there was income from 3 units already present for many, many years. So
when you purchased the property, did a title search?
We didn't have a survey available to us, and I was advised by my lawyer to obtain title insurance, which has refused, of course, to help me with this situation. But yes, because the impact notices said triplex. Now, when I look back, of course, it says duplex, and it states there are 3 units, 2 apartments and 1 in-law suite. So that's the situation I'm in. We were doing some revisions to the unit that I live in, and the permit office notified us, or reminded me, I guess, that the house is still listed as a duplex.
All right. Thank you. Thank you very much. Any comments from the panel on this application? All right. An unfortunate series of events, Ms. Birdie, which probably could have been avoided had a title search been done when you purchased the property. However, that's in the past, and we're dealing with what's before us today. So this is again, the minor variance to permit a reduced westerly side yard to regularize the existing triplex on the property. I'm prepared to accept this application. We will tie this, if we agree to it, tie the approval to the life of the building, which is a pretty standard condition that we impose. All in favor of granting this application? Your application is approved. Thank you very much.
Thank you.
The next application we will deal with is item 4 on the agenda, 48 Havelock Street. Minor variances to permit a reduced interior side yard setback and a reduced front yard setback is proposed to construct a 2-story addition onto the existing dwelling. And we have a Mr. Bloom, I guess. You can see by my last name that I'm a little sensitive to pronunciation and spelling of last names.
I've heard many varieties. So.
Oh, you and I could probably have a good conversation about how many times the last name could be mispronounced.
One thing you can't choose in life, right?
Pardon me?
One thing you can't choose in life.
Yeah. You can hate your parents for it for the rest of your life too. Anyway, I need to you need to swear the oath with us. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I swear that to be the case.
All right, thank you. So if you'd like, we have to make, I should note that there is a, the requested variance, your variance B should read to permit a reduced interior side yard setback east side of 1.
Yes, so the magnitude of the set, sorry.
Yeah, whereas the bylaw requires an interior side yard setback of 1.2 meters.
That's correct.
Okay.
So I was made aware of that error by my neighbor actually at 46 Havelock on the day that he received the notice.
Okay.
Promptly that day corrected it with him or clarified it with him, and also contacted my other neighbor at 54 who arguably is more impacted by this this variance application, and they both submitted letters to that effect.
Okay. So if you could give us a very brief explanation of what you are proposing for the site.
Sure. So maybe we'll start with the site plan and or the render. All right, here they come. It might actually be better to start with the site plan, just so we can give you some sense of what the addition is. Okay, so on the left-hand side there, we see the proposed addition space. It's in the, and I see that the site plan was corrected with the correct north reference. So it's on the northeast side of the building. You can see that the rest of the existing house is going to be unaffected. There will be some obviously cosmetic changes to suit the addition, like siding changes, but no structural changes. And as you can see, my house actually encroaches on my neighbor's property at 50 or at 46. So I'm sure you're all well aware, no changes can be made to a situation like this.
Yep.
So we'll be sensitive to that, of course. The addition is, as I said, on the northeast side. The front setback requirements, it's actually a combination of two requirements. The first essentially states that, and I've made the reference in the initial application. I think it's, I don't have it in front of me, so excuse me for that, but it's the average of your abutting neighbors. There's an additional condition. So you take that number, that is the average. And if you're currently in a non-compliant situation like I am here with a setback of current setback of 2.28 of the existing building, whereas the average is somewhere in the neighborhood of 3. You take the average of those two numbers, and that is your resultant front setback requirement. So that landed at 2.82. And I think maybe I guess on the right-hand side, you can see the addition. You've already had a glance at the render, but this gives you some sense of what the addition is. Yeah, I guess, I mean, you can see on the left-hand side, it's 2 stories plus an attic that's being added. And then on the right-hand side, you can see the existing that's got some siding to suit the addition. We'll go to the survey perhaps, so I can maybe detail a little bit about why this is minor and some of the other tests, which I probably did a better job of in my cover letter, but I'll stumble through it here. You can see my lot in the middle, and the resolution is quite poor, but I think all the panelists have a nice big copy of it. On lot 6, on the left-hand side of lot 6, you can see that my front setback is more or less the same as the setback on 54, which is the right-hand side of lot 6. Mm-hmm. As I mentioned before, the existing house the existing footprint isn't being affected as part of this addition. It's just an addition to the northeast side. The resulting setback and the variance that I'm requesting both lie further back from the lot line than my neighbor at 54. So it won't affect any or obstruct any view from their front yard, from their amenity space. And as I said, so it's set back further from their home. The averaging actually in this particular case, it doesn't serve well, because there's no way to correct the difference between setback. His setback is 4.2 roughly, mine's 2.28. By making this addition, I'm actually going to improve the uniformity of the front setback relative to 54. So I think it's actually an improvement of the current configuration from a setback perspective. On the side setback, I'm requesting a smaller setback of roughly 7 inches. This is, and maybe we can go to the cross section on I think it's page A17 is the reference on my plan, but there it is. Okay, so the staircase that's taking us from the second floor to the attic, it's a pretty tight squeeze. You can see there's a doorway and there's not much margin for error there. This extra 7 inches, if we were to take this away, it would impact only one room. It couldn't be uniformly distributed across the addition spaces because of that staircase. That staircase is at its limit, so to speak. So that's kind of one of the driving factors for the 7-inch side setback request. In terms of an impact on my neighbor, I can say that there's 2 windows, and maybe we can go to the other view, the side view. So there's 2 windows, one on the second floor and then one in the attic. So the attic, obviously not a space that's going to be used frequently, so no privacy concerns there. The second floor window is a bathroom window between my vanity and the toilet. I think I provided a floor plan, but perhaps don't really need to look at it at this point in the interest of time. But that's another window that won't be used frequently. I've engaged with him and discussed this with him, and he has no issues with this. I provided some pictures to the committee of the side gate that it has a 1 meter opening. Just like to note that in approving this minor variance, you wouldn't be further restricting access to that to the rear yard. It's really constrained by that gate, which is 1 meter wide, and we're maintaining that 1 meter distance to the lot line. So actually, I would argue improving the situation a bit, because the column that you can see, it's probably better depicted in the front view. You can see that there will be a 1 meter separation as well between the house and the column, in addition to a 1 meter separation between the column and the lot line. So gives you kind of 2 1 meter width options to access the back, as opposed to, one that's slightly larger than a meter and one that's slightly smaller. So I don't know if I'm beating this to death or not, because this is the first time I've done this, but I'll leave it there for now and see if there's any questions. I have engaged with my local drawing a blank here, local committees. I've reached out to my neighbors, and everyone views this positively. They think it's a positive change for the neighborhood. So I haven't, unless there's anyone that wants to speak today, I'm not aware of any issues.
There's no objections to your from your neighbors to this application, or from the local community association. So, okay. You realize you have to constantly talk to Hydro about electrical services and overhead wiring.
Yeah, so I've been at this for about I would say almost a year now. And so I have quotes for relocating the electric service. That came actually, I would say 6 months ago. I engaged with them to find a solution.
So you're dealing with Hydro, and there's no required conditions from the planning department on this as either. Any comments, questions from the members of the panel? Okay. Are we prepared to vote on this application? I believe. Thank you very much for your presentation, by the way. As a first timer, you did a very good job.
Thank you.
It's appreciated, believe me.
So,
even if your last name is mispronounced.
So is it approved or is it?
Well, that, or you have to
Sorry, yes.
do that now. All in favor of granting this application as modified regarding variance B? All in favor? Your application is approved. Good luck with your project.
Thank you, and thank you for not butchering my last name too badly. It was I've heard worse. So
you're very welcome.
Good day.
Thank you. Bye-bye.
Bye now.
Next item on the agenda are items 5 and 8. 390 Bronson and 239 Cambridge Street. Consent to subdivide the property into 2 separate parcels of land in order to create separate ownerships for each parcel. The application indicates that these lots were previously separate lots that have since merged. And then minor variances to permit a reduced lot area and width. Proposed to subdivide the property 239 Cambridge Street and 390 Bronson Avenue into 2 separate parcels of land in order to create separate ownerships for each parcel. The application indicates that these lots were previously separate lots that have since merged. And before we begin, I note that there's an amendment to our notices for both the variance and the consent. Regarding the variances, it should read one of the newly created parcels shown as part 1 of the draft R4 plan filed with the application will not be in conformity with the zoning bylaw. This parcel will contain a 3-unit residential dwelling, not a 1 unit of a semi-detached, and a detached garage, and is known municipally as 239 Cambridge Street. And the modification to the consent application, second paragraph, the land to be severed shown as part 1 in the draft R4R plan filed with the application will have a frontage of 8.8 meters on Cambridge Street to a depth of 30.2 meters and will contain a lot area of 265.76 meters. This parcel will contain a 3-unit dwelling, it should read, and garage known municipally as 239 Cambridge Street. So with that out of the way, I believe it's Ms. Martins who is the applicant. Hi.
Yes.
Before we begin, I have to administer the oath. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do, yep.
Okay, and if you could give us your municipal address, please.
Yes, mine is 5897 Fernbank Road in Stittsville, K2S 1B6.
If this application, I believe, was adjourned by us.
Correct.
And is back before us again for some clarification. If you could make your presentation now.
Sure,
of
course.
Application.
Yes. So the owner of this property would like to subdivide the property into 2 parcels. It was previously 2 parcels merged by the previous owner due to some marital issues. He would just simply like to separate them and legitimize the 3-unit use of Cambridge, which has been, from what we understand, that way since the mid-1960s.
Okay. And regarding the variances?
We came to our attention that if we severed the lots in 2, that Cambridge would not be in compliance with current zoning. So in order to legitimize the use and bring it into compliance, we would require to reduce the both lot width and lot area and bring it. So that's why we're here today.
Okay. And planning department's position on this application now that things have been, I'm assuming, clarified?
Through the chair, yes, given that they've sought the variances required to accommodate a triplex on, a 3-unit dwelling at 239 Cambridge. We're comfortable with the application. No comments or concerns.
And the conditions the department's requesting, Mr. Nato?
We are requesting that evidence be given of the demolition of the existing garage at 239 Cambridge, just for the sake of compliance with rear yard requirements and accessory structure provisions. And also we would ask evidence of independent servicing for these lots.
And these the conversion of this house was done in 1962.
That's 1962. Thank you. I didn't know the exact year.
So that's 2 years in advance of Ottawa's first zoning bylaw. So you have a legal non-conforming, right? Okay.
Fair enough.
Any questions from the members regarding this application? Any comments, questions? Now that we have that clarification, I think I'm comfortable with the application. Prepared to vote on this application, ladies and gentlemen? All in favor of the application as amended? Your application is approved. Thank you very much.
Thank you.
Thank you. Okay. The next application on the agenda are items 6 and 7, 241 Furland Street. And this is a consent to subdivide the property into 2 separate parcels of land in order to obtain separate ownerships for a proposed 3-story semi-detached dwelling. The existing dwelling is to be demolished. And then there are minor variances to permit reduced lot areas, lot width, interior side yard, and front yard setbacks. It is proposed to demolish the existing dwelling and construct a 3-story semi-detached dwelling. And the agent for the applicant is Mr. Bede. Mr. Bede, are you there?
Hello, Mr. Chair. Yes, I'm here.
Okay, and we'll have to administer the oath to begin.
Yeah.
Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do.
All right. And before we proceed, Mr. Bede, I would like to hear from the planning department regarding their evaluation of this application. And just the question, of course, to the planners is whether or not the infill compatibility policies in the current official plan were considered when this application was reviewed. And I'm specifically referencing OP policy 3.6.1.5 and official plan policy 4.11.
Through you, Mr. Chair, when planning staff reviewed the application, they looked at the policies that you've mentioned above regarding how the proposed development would fit or would be compatible with the surrounding area. In my report, you will note that we have note that although the lots may be undersized, they still enhance the street and the character of the Joliet and Fairland because they have both frontages on the street. So they're creating a legible and more active frontages, which is one of the policies on section 4.11. We also note that in the case of compatibility of lot sizes, there are similar lots or semis that are undersized in the area. And we also note that they are also singles and semis in the neighborhood.
I note that there's an order to comply on this property. Could you have any information regarding that?
Through you, Mr. Chair, unfortunately, I don't have any information regarding that.
No, perhaps Mr. Bede can give us the details on that.
I believe the order to comply is to do with property standards for the existing structure. I don't think that it speaks to the any of the aspects of the proposal.
What's being proposed? Okay. All right. Okay. All right. Thank you. Thanks to planning staff, Mr. Bede. If you'd like to proceed with your presentation.
Thank you, Mr. Chair. As you will remember, we've been here before for this application. We've been adjourned twice to provide for more time to work through the issue regarding Hydro Ottawa's separation and clearance distances. We have had productive discussions with Hydro Ottawa, with the city's legal department, as well as with legal counsel retained to speak to this matter. And we are comfortable that we can move forward. I'm joined here today by my colleague Brian Casagrande, who can speak as well as Jacob Hollowin, who is the legal counsel for the property owner, who can speak more and more detail to the applicability of the hydro separation distances and opinion from us, as well as from staff and Hydro Ottawa, that those considerations will be dealt with appropriately at building permit provision. Okay. So if you'd like, we could speak more to that now to provide comfort with moving forward, or if you feel comfortable moving
forward. Sure, please do.
I'll pass it along to Jacob to speak in more detail.
Thanks, Tim. Good afternoon, Mr. Chair. So from the perspective of the jurisdiction of the committee and what's actually before the committee right now, it is our view, and my understanding is that this is shared by the city's legal department, that what's actually in front of the committee is the variances and the consents themselves, and that the issue of hydro separation is not an issue that's relevant at this particular stage. That would be an issue that's relevant at the building permit stage, and our client is obviously aware that they're going to have to work with the city's building department and with hydro in making sure the hydro is comfortable with the construction as proposed. But it's our view that that should not impact the committee's analysis of the permissions in front of it. And we also, I believe, there was a letter sent to the committee on November 2nd by Chris Murphy of Ottawa Hydro, and I don't know if you received that or if that's been circulated. Sorry, is that?
Yeah.
Yes. Okay. So you'll see that our position is shared by Hydro, and they're comfortable saying that the required clearances, the clearance issue will be reviewed and handled during the building permit process. So, and I mean, that's quite simply our position on that. And I know, as I said, shared by Hydro and the city, and I'm happy to answer any questions.
Okay, thank you. Thanks for that. Please, okay. Mr. Bede.
Okay, thank you, Mr. Chair. So I'll start by saying that I'll get into more detail in terms of the site context, the applicability, and of the variances requested and their minor nature. I'll just start by saying the proposal represents a low-rise build form. It has been designed with the current form of the existing structure, as well as the as-of-right zoning permissions as guiding principles. And we referred to that often and frequently throughout the design process to ensure that the proposed building is in keeping with the existing character and of the neighborhood. The proposed use is permitted, and it represents an important investment in a more affordable homeownership option in the area, which we think is an important contribution. Furthermore, and I believe these were circulated to committee as well, the neighbors, the most immediately abutting neighbors on the rear and interior side yard have provided letters. We've had ongoing conversations with them, and they both are fully aware of the application and support approval of the relief required. So as you mentioned, our purpose of our application today is to seek permission for reciprocal severances of the existing parcels into 2 separate lots with a right-of-way easement for ownership purposes and the construction of a 3-story semi-detached residential building on the entirety of the lands. The minor variances are requested to address non-conformity with certain zoning provisions. for both the severed and retained portions of the property, and the existing building will be demolished. As I mentioned, and this is important, I think, in how the design was arrived at, the footprint, scale, and massing of the proposed building was designed to not only reflect the existing condition, but also the permitted as of right provisions under Section 3 of the zoning bylaw, which addresses redevelopment or expansion for non-conforming, non-complying buildings. We are having ongoing discussions with, and we have had those with the property owners immediately abutting the subject lands, and we believe everybody's on the same page and supportive. I can't see my presentation. I believe it's up, but we'll go to the next slide after the intro slide. So just a little bit of a context. The subject property is located in Rideau Vanier, in the established neighborhood of Vanier North within the greater Vanier community in the city of Ottawa. Next slide, please. It's a corner lot of the subject property with a total area of 186 square meters with 12 meters of frontage along Furland and 15 meters of frontage along Joliet Avenue. Next slide, please. The subject property is within the vibrant Beechwood Avenue traditional Main Street area. It's very close proximity with a number of services and amenities in close proximity. Numerous amenities are in walking distance, including schools, parks, services, employment opportunities, which will serve to accommodate the slight increase in density proposed on the site. Next slide, please. The property is currently zoned residential 4th density subzone E. The intent of this zone is to accommodate low-rise residential built form up to a height of 4 stories. And the R4E zone is also applied to allow a wide mix of residential building forms, ranging from single detached semis to low-rise apartment. And it regulates development in a manner to ensure compatibility with existing use and patterns and the residential character of the areas zoned R4. So importantly, it permits semi-detached buildings up to a height max of 9.5 meters, which our proposal complies with both of those important provisions. Next slide, please. The subject property is designated general urban area in the official plan. And again, the general urban area designation permits the development of a full range of choice of housing types to ensure people of all ages and incomes are able to find appropriate housing for their life circumstances, and also to be conveniently located with proximity to employment, retail, cultural, leisure, and entertainment opportunities, and be compatible with the existing built form, which we believe the proposal does. Next slide, please. I'll speak briefly to the lot fabric, as I think it's important in terms of informing our built form proposed here today, and the proposed severance and details of the new lots we are proposing to create. The neighborhood consists of predominantly low-rise residential buildings with a variety of architectural styles, containing many townhouses, low-rise apartment buildings, semi-detached and single-detached. A 9-story mixed-use building is located diagonally across the street, along with frontage on Beechwood. Next slide, please. And this is showing the interface with the interior yard neighbor and the rear yard neighbor. Both property lines abut the driveway and parking for those two buildings. And you'll see on the left, the interior yard neighboring building is a 3-story multi-unit with predominantly blank wall facing the subject property. Next slide, please. And again, just showing the context of the immediate area and the variable built form within close proximity that has helped to inform our design. Next slide. And I'll go to the next slide as well. Thank you. So many buildings in the area have been located in close proximity to the street with minimal setbacks, narrow lot widths, creating a more direct and vibrant interface with the public realm, and a vibe and an atmosphere that's very pedestrian oriented. And with that enclosure and street edge animation that makes for a positive pedestrian experience. You can see within very close proximity of the subject site are multiple 2 and 3 and 4 story buildings. As I said, within close proximity to the subject, to the property line, and with various ownership and tenancy opportunities. Next slide, please. This is meant to detail the variable lot widths and front yard setbacks located in close proximity to demonstrate that the proposal will be in keeping and reflecting and respecting the existing character. So we see lot widths throughout the neighborhood. They vary quite a bit, but there's ample example and precedence of lot widths between 5 and 6 meters and front yard setbacks between 2, 3, and 4 meters, which is reflected in our proposal. Next slide, please. So the proposed, I'll start with discussing the severance and easement. The reciprocal consent applications are meant to create 2 separately conveyable lots, so for ownership purposes, for the sale after redevelopment. Part 1 to be severed is north abutting Furland with a size of lot size of 87.5 square meters and a width of 5.75 meters. Part 2 and 3 have a size, they're fronting, Joliet, have a size of 98.4 meters and a width of 6.45 meters. And then part 3 will be the right-of-way easement over part 2 in favor of part 1 for right-of-way and to accommodate the proposed parking area. Next slide, please. So as discussed, section 3.3 of the zoning bylaw establishes provisions for construction and additions to existing non-conforming and non-compliant buildings. So using these provisions, as of right concept was created. To inform the design and layout of the proposal for the semi-detached. We can see the as of right footprint in this in this proposed site plan in the hatched blue area, indicating that the as of right footprint could be slightly larger than our proposed design. And the table at the top of the slide there indicates, as was mentioned in previous presentation today, the provisions within the zoning bylaw which speak to existing conditions, provisions of the zoning bylaw, and finding that average to determine as of right expansion and redevelopment on existing buildings. Next slide, please. So this exercise was important to better illustrate the proposed built form and how it would be permitted currently without requiring applications for minor variances. The built form, importantly, could also accommodate a secondary dwelling unit, allowing for 2 units as of right in a almost identical built form. So the application is triggered, however, as the provisions of the semi-detached dwelling vary in the zoning bylaw slightly from a single detached building. Next slide, please. So the proposed building will consist of 3 stories, 9.3 meters in height, a finished basement with a building footprint of 92 square meters, a gross floor area of 236 square meters. Total coverage of the lot is 49% of the lot, allowing for ample space for landscaping, which is to be determined, but currently is proposed to include bushes, cedar, hedges, and things of that nature to ensure adequate and appropriate landscaping program on the site. The remainder of the land, this would represent a significant improvement to the existing condition, where the corner is occupied by illegal structures and surface parking, which represents a driving and safety hazard and an impediment to desirable landscape on the street. We've only included in this building design 1 parking space off of Joliet to further augment and improve the landscaping opportunities on the site. Given the dimensions of the lot, the design approach attempts to make full use of the available buildable space in order to yield functional interior units, while also ensuring neighborhood compatibility, adequate transition distances, and a high quality design. So to minimize the massing and shadowing or any concerns of privacy on the abutting properties, and to respect the as of right potential, the building design includes multiple and strategic step backs for the 2nd and 3rd floors. Along Furland, for example, the 2nd floor steps back another 2 meters after the at-grade condition. And then it is also then able to provide balconies for the 2 units, so outdoor amenity space. Also, the rear building steps back to a total of, the rear of the building steps back to a total of 3.14 meters from the lot line, which is in excess of the bylaw requirement. And the rear and side yard elevations have been designed with minimal windows to ensure privacy for abutting property owners. Next slide, please. So we'll just go through the two renders, which indicate the design approach to the building with the step backs, glazing at grade, and the step backs on the second and third floor, which minimize the building massing and reduce any concerns with shadowing and overlook. Next slide, please. So in this front elevation for facing onto Furland, we can see the at-grade glazing, the prominent front entry feature, as well as the landscaping along the corner side elevation. Next slide, please. In the side elevation, this is from the corner side, we can see the reduced building massing on the second and third floor. Next slide, please. And the rear elevation, which has minimal and strategically located window placement to ensure protection of privacy or reduction in any concerns in that regard. And next slide, please. And again, the interior side yard elevation with no windows on that side, as well as the reduced massing to best respect and complement the community while ensuring functional units for both of the units in the semi-detached proposal. Next slide, please. So I've included the next two slides. As Jacob mentioned, we don't believe that the hydro considerations are, within the discussion that we're having today, and they will certainly be addressed at building permit. I wanted to showcase the minimal overlap between the hydro clearance distances and the building. As you can see here, and we'll move to the next slide. As you can see in these two slides, the only portion of the building which is impacted by the potential hydro clearance is the top corner. So leaving opportunity for either a relocation of those high voltage infrastructure pieces and or a slight redesign of that small portion of the building to ensure compliance. That will be something that could be addressed in the future, and it won't impact any of the variants requested. In that light, if a positive decision is made for these variances today, we would probably request that they aren't tied to the elevations or plans to allow for some flexibility in terms of minor redesign of that portion of the building. Next slide, please. So I'll just go briefly over how we believe this proposal adheres to and respects the 4 tests of a minor variance under the Planning Act. The variances maintain the general intent and purpose of the official plan. So as mentioned, this is in general urban area of Schedule B, or a low-rise semi-detached 2-unit dwelling, which adheres to the general intent of the designation, allowing for a variety of built forms, modest residential density with considerate and complementary design features. The proposed building complies with the relevant permitted uses, urban design, and compatibility policies of this designation, and will integrate well with the existing context as it's demonstrated throughout this presentation, and designed to respect the established low-rise residential character within the immediate context of this proposal, the subject property. The test 2 variances maintain the general intent and purpose of the zoning bylaw. So we're considering the proposed use semi-detached and built form low-rise. Those are both permitted uses and permitted under the zoning. It reflects the general intent and purpose of the zoning bylaw, and the provision of a new compact ground-oriented housing typology also promotes this purpose and intent. So although variances for lot area, lot width, interior side yard, and front yard are sought, some of these reductions, for example, lot width and interior yards, are close to the minimum requirements and or meet or improve on the existing conditions. As noted, the footprint and scale and massing reflects that existing possible for an as-of-right rebuild of the site. And the total lot width of all parts is actually 12.2 meters, and is in total, when considered as a whole, is compliant with the provisions. The front yard setback is representative, as it is at the 2.2 meters, of the varied reality in the immediate context, with immediate neighbors with front yard setbacks from 2 to 3 meters, and reflects the existing condition of the property currently. Number 3, variances are desirable and appropriate for redevelopment of the lands. This redevelopment will allow for a high quality purpose-built semi-detached dwelling unit, which through the appropriate use of materiality, design, landscaping, and overall building scale will respect and reflect the existing character and low-rise nature of the area. The reduction in lot size and width is deemed appropriate given that the intent of the proposed redevelopment plan is to generate modest intensification and additional residential opportunities in close proximity to various amenities and services, including transit, schools, parks, grocery stores, things of that nature. The design also includes ample landscaping in the front and corner yards, as well as the site triangle, which, as mentioned previously, means that the building coverage is 50% with 50% for hard and soft landscaping. And the proposal represents, again, a more affordable homeownership opportunity, which is something that is often cited as a missing piece of the home ownership and affordable housing or attainable housing within Ottawa. And finally, the variances are minor. The existing development condition of the subject lands is one of non-compliance on all setbacks. So there are no increased shadowing or privacy impacts expected on the existing residential neighborhood in area as a result of this, as the building is compliant in terms of height and massing. The proposed development will allow for compliant corner and rear yard setbacks that meet or exceed the as-of-right conditions and step back further on the second and third floors. As mentioned, the front yard setback is consistent, although non-compliant with the zoning provision, is consistent with the existing building as well as with the immediately abutting neighbors. And the proposal offers a rear yard parking space for the interior unit via the right-of-way easement requested, and proposes no parking spaces for the corner unit. This means that we will exceed the bylaw provisions for parking, but it significantly improves the existing condition and reduces hard surface landscaping that would be required for a second parking space. The reduced interior setback portion abuts the driveway and parking area for the abutting property and is designed in such a way as to avoid overlook. As well as mentioned, the property owner of that building it has been informed and is supportive of the design. So in all, the requested minor variances promote and accommodate a development that on a whole will significantly improve the existing condition, provide a more context appropriate development, and therefore the variances requested today can be considered minor in nature. Happy to answer any questions you might have at this point.
All right, could we go back to the graphic that shows hydro setback easements?
Yes.
Setback requirements. Okay. You said, Mr. Bede, in your comments that there might be revised elevations to meet Hydro's conditions. Has Hydro seen these elevations?
Yes, Mr. Chair, these elevations have been circulated to Hydro.
And have they agreed with the infringement on their setback requirements?
So this will be considered at building permit through the building inspector. Hydro has provided their comment, which will be considered. The other option would be to relocate the Hydro infrastructure in a way that ensures the separation distances can be met. That's something that will be considered as they move towards building permit.
So we could end up approving this today, and you may have to significantly alter the design of your building at the building permit stage should there be no agreement between the applicant and Hydro. Am I correct in my assumption?
I think that some design options that could be explored could be minor in nature in a way that they could ensure that they're outside of that small portion of the top corner of the building, which is currently within the area of clearance. But that's something that hasn't been explored fully and will be once we have a better understanding of how that could impact the building. And, after potential discussions with Hydro are concluded in terms of if potential relocation of the hydro wire is an option.
Which Hydro, generally speaking, is loath to do.
I believe, Mr. Chair, in previous experiences, I believe that it's on a case-by-case basis, depending on the circumstances on the site. It's something that we would like to explore, or as you mentioned, a potential slight redesign of that portion of the building to ensure compliance. We don't believe that that would impact the variances requested today, as the building has been designed in a way that we think that it could still work with a small design change in that area.
Yeah. Thank you. Mr. Wildman, you have an expertise in infrastructure, and you may have seen this type of thing before. Your comments or concerns regarding this?
Well, looking at the plan, which shows the clearance, the swing clearance, in conjunction with the commentary that we were provided by staff on our cheat sheets from Hydro, it appears as though Hydro is saying, look, it's on you. The cost of either relocating or redesigning are on the developer. I'm not sure that my suspicion would be the only way to deal with it from the Hydro line would be to bury it, which is incredibly costly. And then, the other alternative is to have a building that it gets redesigned. Sometimes I've seen this happen at the building permit stage, but my goodness, that's a lot of going backwards if you haven't got your ducks lined up with Hydro. My view is that if it were me, I would want to have it resolved now, not later when Hydro says it's going to cost you another $50,000 or so. But when I look at that, I guess I raise an eyebrow with some concern. I'm not sure that I necessarily agree when we look at the applications that are before us in totality, whether they're separate and distinct, recognizing the commentary from Mr. Pollan. So I guess the committee is going to have to wrestle with that a little bit before we render a decision. So it would be my recommendation, Mr. Chair, that we should reserve on this one.
I agree. Any other members wish to comment on this application? Mr. Wilder.
Mr. Bede, you mentioned there's only one parking space that's being provided. Can I just see the site plan again to show where the access is and where that parking space is going to be if we have the site plan? If I can ask the coordinator to put that up.
So the parking space will be located and accessed off Joliet. And
maybe you can just, maybe you can just, okay, off Joliet. So I see where there's a covered port. I see the interlock. I see the show me exactly where the,
it's at the top of the site plan there. I guess just underneath where it says proposed site plan.
Right.
The area there coming in off of Joliet to the.
Where it says plaster, the little line there, plaster protection above. So it's just, I see where it's so.
Yeah, in that location.
And that meets the width of the drive.
Yes, it's, the provisions are adhered to for the driveway width and parking space width.
So the next question is why the need, if there's only one parking space, why is there the need for, as you're showing in the site plan, asphalt? We got such a small site, narrow setbacks. Why the need for asphalt? If you only have one parking space, why is asphalt going right across the back?
The provision of the zoning bylaw states that a parking space cannot be in the extension of the front and side yard, and therefore it has to be in that location to adhere to the provisions of the zoning bylaw.
So you need you need the full extent, in other words, of the backyards of both semis to have asphalt for that parking space. Is that correct?
To adhere to the provisions of the zoning bylaw, the location has to be in that location in order to be compliant.
And you need that much area, in other words, of asphalt for that space to accommodate that single parking space. When you have so little landscape space available, you've got one tree in the far corner at the front yard. You've got some grass along the side. I realize you have the 2 balconies, but in terms of green space, in terms of, I'm looking at the comments provided by the Vanier Community Association. I appreciate some of their comments about this being a very, very small site. By severing them, basically the lot sizes are very small. I still can't figure out why you need the asphalt on both lots. Explain that. I'm still lost on that. I'm sorry.
Yes, through you, Mr. Chair. The early on in the design considerations for this project, we actually removed a second parking space, which was accessed off Furland in an attempt to kind of speak to your concerns and the community association's concerns, as well as ours, in terms of ensuring that even though the site is tight in terms of how things will fit, we wanted to make sure that we had as much opportunity for soft landscaping and tree and shrub planting. The provision of the parking space is in that location simply because of the requirements of the bylaw for width and length, as well as for location of the actual parking space, which must be outside of the front and side yard. So in order to locate it in any other space on the lot, variances would be required. And it wouldn't be also in keeping with the kind of a character and existing lot layout of other nearby residential buildings, which all traditionally and in adherence with the zoning bylaw have located their parking spaces in similar locations.
So the property on Furland won't have a parking space, correct?
So physically the parking space is located to the rear of the Furland unit. However, the easement that we're requesting today is the right-of-way easement to provide for parking for that unit.
So to get that parking space, the entire rear yard, basically from Joliet right over to the far end of the property, has to be asphalt to accommodate that one parking space.
It's in defense of the design, it's the most minimal amount of parking space in asphalt to accommodate that parking space that could be provided based on the requirements.
Mr. Nadeau, is parking required on this property for either unit?
The zoning bylaw does not require parking. However,
correct, it does not require parking. You've got a very tight site on this property, subdividing into two very small lots. I don't really see a need for that parking space, to be honest with you. I'm sort of disappointed with this plan, the way it's designated. When you're working with such a small site, and I appreciate that, I don't see the need when parking is not required, why that vehicle is required. Anyway, that's one of my questions. The other question, you met with the community association. Apparently, my understanding was there are not to be any secondary dwelling units. Is that correct?
Yes, through you, Mr. Chair, that's correct. We had a number of conversations with the community association. One of their initial concerns that they had raised was what they felt was an ambiguity in terms of the total unit count. So part of that discussion, we clarified that this will be a 2-unit development, semi-detached, and it's been designed purposefully for those uses. There's no intent to include additional dwelling units within this proposal.
And one other question, just as an aside, your firm has used the word, Mr. Casagrande knows this, the word affordable homeownership. I know the area well. What exactly do you consider to be affordable homeownership for each of these units?
Thank you for the question. I think, to be fair, we could say more affordable, more attainable.
Thank you. That's all I want to hear.
I
It's
think
more
that it's a more,
affordable. To say it is affordable without knowing exactly what the price is going to be and doing comparables to the area is really unfair. But thank you for that.
yeah, I think just to elaborate slightly, if you will, I think that providing a building typology that's maybe slightly more attainable for a first-time home buyer than, when compared to a single detached in the area. The idea was that this could possibly provide that opportunity for getting into the housing market through a more attainable or more affordable housing typology.
We're talking $500,000, $750,000. Your client hasn't indicated to you what the price range is, have they?
No, I'm not aware of what that would go for.
Yeah, right. Thank you very much.
Thank you.
Mr. B, just to pick up on the 2 units only on the site, the applicant has agreed that this will only be a semi-detached dwelling?
Thank you, Mr. Chair. The proposal as it stands today is for a semi-detached for 2 units. As mentioned, one of the reasons for requesting the severance is for the purpose of sale of the property. So, we can't really speak to future uses on the site, but it has been designed and is intended to be built and sold as semi-detached with a unit, 1 dwelling unit per. So, as far as we know, and as far as it's been designed, yes, it will be a 2-unit semi-detached building.
But your applicant, anybody who's buying this property could still convert and put a secondary dwelling unit in each one of those units if they wished, if they met the bylaw requirements.
I guess that's possible, and it's true of any development. There's future considerations that are difficult to speak to. It is, as you know, these are efficiently built and designed buildings and or units, and therefore functionally it seems to work best as 2 units, one per in the semi-detached. And I'm not sure about the functionality of including another unit, say in the basement or something like that. I don't think that's been considered and isn't something that has been part of our discussion and our design exercise. But
okay,
I take your point.
Okay, I just wanted clarification. Thanks very much.
Mr. Chair,
Mr.
sorry,
Castaneda.
would you permit me to, I just wanted to offer one idea maybe in response to Mr. Wilder's concerns related to the parking and the green space. One of if the site plan could stay up, I think it would be helpful, but one of the things that we thought about and the committee could consider if that's an abundant concern is the front unit, the unit where the driveway is located leading to the parking space. I think the owner would be quite happy if the committee thought it better to basically have the parking space on that lot sitting in that driveway basically, and leaving the opportunity for the space behind the interior unit to just have a green backyard. The concern we had is that distance from building face to interior property line is not quite long enough to satisfy the minimum required parking space depth. And so we would have had to either seek another variance, or we would have had to ask for permission to have an easement to park on the interior properties, a couple of feet in, if you will. And so, we didn't want to complicate what is, admittedly an already, challenged site in some respects. And so we thought we would keep it simple, if you will, with respect to parking. Eliminating parking altogether, is an option too, but the concern I think the owner has and we would have is, we often hear communities complaining about not providing enough parking. And so it's striking that balance. So we thought 1 parking space for 2 units was a reasonable balance. But as I'm saying, if the committee would be willing to permit us a variance on parking space length for the outer lot, then I know the owner would be just as content with that.
That would force us into recirculation, I do believe.
Yes, I don't know how the committee's, policies or regulations are with respect to that, if they can make adjustments when it's actually heard. It's not a required variance, as you know. It's one it might be sought to address an issue. I leave it with the committee. The only thing I guess I'd say is if that was, we'd appreciate not having to come back if the committee's going to be concerned anyways about everything else again. But if that was a fundamental thing that could satisfy the committee's concern, then I think the owner would be happy to come back again. The other thing actually I did want to make a comment on is I do respect Mr. Wildman's experience with respect to hydro. It definitely outstrips my own, but our thinking is that the opportunity to both either raise the pole slightly or have the line shifted to the interior side of the pole, which I've seen done at owner's expenses, both would be an easy way of satisfying the setback issue if in fact we're forced to comply with it. So I don't see burying the lines as the solution that the owner would likely go toward. The cost would be extremely prohibitive. And my sense is they'd likely just build something different as of right, which would be effectively a single family home on this property if they were faced with that reality. Our hope is that we're going to be able to find a way that's going to allow this to work, because we do think it's an appropriately designed site and building.
Okay. Mr. Casagrande, if the parking was relocated to off of Furland Street, I'm just looking at your site plan. What's the distance between the property line and the front wall of the house?
No, I want to clarify, Mr. Blatherwick. The parking space where I would envision it going is where the existing driveway is shown now.
Okay.
And so I'm just saying that the front wall of the building doesn't allow for enough parking space depth. So we'd either have to be permitted to have some front yard parking or a shortened stall, which could work with a lot of cars.
Okay. All right. Okay. Thank you, Mr. Casagrande. Any other members have any comments on this application or questions? Ms. Auxcharon.
Thank you, Mr. Chair. My question surrounds the test for minor, and I'm reading from the planning rationale section 4.1.2, where it leads in and says, in Ontario, a minor variance is deemed a small variation from the requirements of the applicable zoning bylaw. So I'm wondering if you can add any details for me, in particular referring to the lot area variance, to convince me that this is a minor request. Thank you.
Thank you. Through you, Mr. Chair. The lot area variance, the lot, as was demonstrated, is already a smaller lot and could accommodate, as we've discussed, a single detached as of right with a secondary unit. Where the variances come up in terms of this application is simply because the semi-detached built form has a slightly, would trigger that to be a consideration. So although they are smaller lots than would be permitted within the zoning bylaw, the condition as it works on the lot functionally and would continue to work would be the same for the semi-detached versus a single detached with a secondary dwelling unit and built as of right. So we understand that when taken separately, that the two proposed separated lots are smaller than what you would expect in terms of adherence to the zoning bylaw, but don't believe, in our opinion, that they would functionally hinder any appropriate use or redevelopment of the lands, and that the semi-detached building can be accommodated quite nicely on this lot with the provision of the one parking space with front yard and corner side yard landscaping, with some of those attributes still kind of retained and therefore would still fit well within the existing context.
Okay, thank you. I do appreciate the unique architecture and interesting design approach with the application.
Any other questions, comments, concerns from the panel? Final comments, Mr. Bede?
Mr. Chair, maybe I could just ask a couple of questions.
Certainly.
Just a question on deferring the hydro issue to the buildings permit process. Under the Planning Act, the committee is required to look at the subdivision criteria set out in 5124. And one of those is the adequacy of utility and municipal services. So I just wondered whether Mr. Bede or Mr. Paulowin would address this. Is it not the committee's responsibility to ensure that hydro is available?
I'd be happy to answer that, Mr. Chair. That criteria, in terms of the adequacy of services, that refers to the question of whether or not there's actually adequate municipal hydro and utility servicing for the structure or for whatever the permission is. And so in this case, there clearly is. It's an existing lot. There's a building there. There's no question that there is adequate municipal infrastructure, including hydro. So that's what that criteria actually refers to, and not to the location of a hydro line that may or may not be impacted by this. And so, yeah, basically that's the short answer to that question. That's not what that criteria refers to.
Okay, thank you. And then to Mr. Bede, you mentioned about non-complying standards. So is this proposal taking advantage of some non-complying standards in addition to the minor variances being requested?
Through you, Mr. Chair. No, to clarify, the building form, the layout, the design, the massing, were heavily informed by the as-of-right permissions that would be attributed to the design of the building through the section 3 of the zoning bylaw, which speaks to additions and renovations on a non-complying building and structure. So there aren't any additional variances that are addressed under that. It was simply an important part, we felt, of the design exercise to look at what was existing on the site, what could be built as of right, and do our best to represent that and to propose a building that reflects that, to minimize any any concerns of inappropriateness of size or scale on the site. So it was an important part of the design considerations, but not impactful in terms of the variances required for this proposal.
Just a point of clarification, Mr. Chair. I think Tim didn't mention this. So the as of right that we're showing and base the design on is that of a single. So if someone were to take knock down this existing building, but utilize the non-complying rights that it benefits from and build another single with a secondary dwelling unit in the basement, so effective, or anywhere they like, so effectively the same number of units, the same built form as a single, is the same as what we're asking for in a semi. But because we're asking for a semi, because it's a different use, it triggers the need to not benefit from the non-complying rights, but to simply ask for those benefits as it relates to the variances that are sought. So in other words, if we didn't propose a semi, we wouldn't need anything in terms of committee of approval to build exactly the same shape and built form that's there. We would have to deal with hydro the same way, which is why I mentioned that if all else fails on this application, that would be an alternative that they could revert to. So from us, from a planning perspective, we're saying, why would one care, if you will, about dividing the same built form vertically as opposed to horizontally, which wouldn't be an ownership situation in a secondary dwelling unit, but that's effectively how two different individuals or families would live. Does that make sense?
Yes, thank you. It looks like this lot was previously divided. Just looking at the circulation plan, I'm not sure if you have any history on that. And the other question I had is whether you have a contextual plan that shows the proposal in context with 243 on Furlan and 37 on Joliet, like in one plan, rather than photographs and sort of trying to surmise what the proposal will look like. So I just wondered if there was one plan that showed that or not.
We The plans, through Mr. Chair, the plans submitted with the application package were based on the surveys that were done and therefore have the outline and the position of the neighboring properties on them, not within this presentation, but should be within the submission package, I hope. But also the renders that were included within the presentation will showcase the interface between the proposed building and the two immediately abutting neighboring properties. We could go to that now if you'd like. And then in terms of the history of the severances on this lot, it does appear that it likely had been severed at one point in the past. There isn't, when you look into some of the historical evidence on the site there, we couldn't really determine a timeline for that, but it's been quite some time. If you look back in historic archived aerials and things of that nature, the lot size and a building on that lot have been there for quite some time, at least the 50s or 40s, as far back as the aerial archived photographs go, as I could determine. So here we can see the proposed building with the built form massing of the immediately abutting neighbors on both the interior side yard and rear yard interfaces there.
And I guess my final question, and then thank you for that, is that are you allowed to put any landscaping in that corner site triangle, or is it restricted to a certain height, or?
Yes, you're allowed to include landscaping features up to a height of 0.75 meters, 75 centimeters. So that would be low bushes or shrubberies and things of that nature. But anything above that height is restricted for safety purposes, really, for view planes and pedestrian and traffic interactions and safety. So you're limited in what can be proposed in that portion of the property.
Okay, thank you.
One question I have, I think Mr. Casagrande mentioned the fact that this, and you have, is the non-complying provisions in section 3.3 of the zoning bylaw. And I'm assuming you're referring to the existing dwelling that's on site. Exactly how does that not comply with zoning bylaw?
So the existing dwelling on site is currently non-compliant in terms of, so the outline of the building that we've proposed represents the built form of the existing. And so it doesn't comply in terms of, well, lot size, as well as front and interior sites, yard setbacks.
That's the current building.
Mm-hmm. Yes, sir.
Okay, all right. Okay, any other questions, comments from the committee? Mr. Wilder?
Excuse me, sorry, do you have, Mr. B, do you have a elevation or a schematic showing the rear of the building of the two assemblies?
Yes, sir. It was included within this presentation. I believe that is it there, yes.
So in fact, you've got windows. This is the lower level, I guess, has a large wide window there, I guess, next to the brick. Is that correct?
That's correct, sir.
And that's going to be looking right out onto the asphalt. Is that correct? Which will lead right up almost to the back of the building?
In the current site layout, yes, that is correct.
Jeez. All right. So in other words, the individual who buys the one half, of course, who doesn't get the parking space, they get the same design, correct?
So that window is actually for the unit facing onto Furland, and the parking space will be provided for that unit. So that's their parking space.
Okay, and I got you. All right. So that looks right onto, all three windows look right onto, especially lower onto the asphalt. All right, thank you.
Other questions from committee members?
Yes, Mr. Chair, just two quick follow-up questions, if I may. Mr. Casagrande mentioned the possibility of shifting the line on the pole, which I did consider, but in looking at the schematics that were provided, it didn't look like that was achievable. I'd like to ask Mr. Casagrande, has there been any discussions with Hydro that is something that is a feasible option?
Yes, Mr. Wildman. I don't believe they've gotten to that depth. We had hoped that that we could have, but contacting them is not always the easiest process. So
Yeah,
it's
fair enough.
seen done in the past, and
Yeah, no, it has been done. It just from the swing that was shown on that sketch, it didn't look like shifting it would really get you where you needed to go when you look at some of those dimensions. Okay, and secondly, maybe for you, Mr. Casagrande or Mr. Paul, and following up on Member McLean's comments, one of the things in section 51 is the requirement to adequately show the nature and extent of any restrictions affecting the land that's proposed to be subdivided. And further on, it says that the approval authority may refuse to accept or further consider the application if something's left unaddressed. So I take you back again to the hydro. It's not clear to me, that's why I asked Mr. Casagrande, it's not clear to me that this is resolved.
I guess if I can respond to that, Mr. Wildman, it's not resolved, but I guess our position on it is it's resolvable. And so whether it's a resolvable by having to cut a notch into that building, or whether it's resolvable by shifting the hydro lines or raising them, or a combination of the two, one of those things will be employed to resolve this. So from our position, given that this is a building permit issue, it's a building code issue, it's something that the committee can comfortably consider the application and defer the matter to be resolved. The key thing for me is to not take a condition that would obligate us to not be able to, or restrict us to not be able to make said modifications if and when we have to do it.
Which is why you don't want to tie it to the plans.
Ideally, or have some wording in there that gives us the flexibility to look at that third floor, which is what you can see is going to be the one that would be affected.
Fair enough. I'm satisfied with the response I got from you, Mr. Casagrande. Thank you.
Thank you.
Anything else from the members? If not, I'll read off the conditions, gentlemen, which I'm sure you're well aware of, that the planning department has requested. Cash in lieu, existing services capped, independent services identified, grading and drainage plan is needed, joint use and maintenance agreement, accessory structure removed or relocated, and the requirement to convey a 3x3 meter corner site triangle. You're aware of those conditions? That's okay. All right. I think what we're going to do. Thank you very much for your presentation, gentlemen. I think what we'll do is reserve on this application, and you'll be hearing, you'll be receiving the decision in 10 days. Thank you very much for your time.
Thank you, Mr. Chair and committee.
Thank you, Mr. Chair.
Right. Next application on the agenda are items 10 and 11, and they refer to 225 Glen Avenue, brackets 11, 13, 15 on bracket Quill Street. Consent application to subdivide the property into two separate parcels of land in order to create two new lots with separate ownerships of a 3-story single detached and a 3-story semi-detached dwelling. The existing detached building and garage will be demolished. Minor variances to reduce lot width and area, front yard setback, and increased building height to permit a proposed 3-story single detached dwelling and a 3-story semi-detached dwelling. This application was adjourned at the planning department's request on October the 21st, and I'm just wondering if the planning department is now in agreement with the application as it is before us.
Yes, Mr. Chair, the department is on board at this time.
Okay. And while I have you there, Mr. Netto, once again, the OP infill compatibility provisions, this application in your opinion, meet, and the department's opinion, meet the requirements? And
Yes, in our estimation, it does. We find it to be an attractive and sensitively designed development. I would like to point out that the Community Association for the, I believe it's Overbrook, raised a few interesting points on the urban design of the proposed units. While it's not our position, or it's not our mandate to require this stuff, these might be worth considering by the applicant as means to further improve the attractiveness of this development.
Thank you, Mr. Netto. All right, is Mr. Luttrell there, please?
I am. Can you hear me okay?
Certainly can. You're going to have to administer the oath first before we begin. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do, yes.
All right. So if you would like to proceed, please, with your presentation.
All right, so I'm not sure who's going to be doing the driving.
If we have contextual evidence, it would be useful.
Yeah, so just for a little bit of context, how our thinking goes on this is that a lot of these variances are based due to the fact that we decided to kind of reorient the lot towards Quill Street, where the current lot is a small single family house that requires demolition for just it's kind of a decrepit condition at the moment, which is now facing Glen Avenue with a garage at the rear of the property. Now, we are looking to orient all the properties towards Quill Avenue with the single family with a door towards Glen Avenue. But generally, if you look at Geo Ottawa or a streetscape, you'll note that pretty much all the buildings on Quill Street actually face on Quill Street. And we're just kind of trying to reorient this new development to be more in what's with it currently existing. So if I start with the single family home, you'll see that we're requesting 4 variances, as you mentioned. So reduction of front yard setback, of building height, and to the lot area and lot width. And if I go to the semi-detached, we're looking for similar 4 variances. So a reduction in front yard setback, an increase in building height, and variance in lot area, and a small reduction in rear yard setback. Now, to start with the the front yard, again, as I mentioned originally, this was a long and narrow lot that faced onto Glen Avenue, but as the neighborhood has been evolving, lots have been becoming a little bit smaller, and we find that in this new context, houses facing onto Quill Street, they fit a little bit better urbanistically, and again, having them a little bit closer to the street fits that new kind of urban context. And you'll see that in the neighborhood, and especially along Quill Street, a lot of new homes have followed this similar pattern, and we're just trying to adhere to this new pattern. So if we look at a couple, just if I go to Geo Ottawa here, I can name a few addresses that. So there's a new development to the north which are semi-detached buildings which are adjacent to the property, and that is 6 and 7 Quill Street, which are very similar in setback, which is around 3 meters, which we're asking. 3 and 258 Donald, also similar setbacks. And then on the other side of the street, if you look at 4 Quill Street and 6 Quill Street, as well as 217 Glen Avenue, all these properties are of a similar front yard setback. And this kind of argument applies to both the semi-detached as well as the front, or as well as the single on the corner. As a result of the proximity to downtown core, like I mentioned, the neighborhood as well as the OP is asking for kind of more denser urban neighborhood, especially close to transit and downtown. So we see this kind of housing typology that's a little bit taller and narrower. Semi-detached homes are popping up in this neighborhood left and right. And we think that what we're proposing is fitting into this new neighborhood. And, you know, as mentioned in the previous application, there is a more affordability by increasing kind of the offering of homes here. And although we're showing the single at 2,200 square feet and the semi-detached at 1,800 square feet, in reality, because we have kind of a garage at grade, if we looked at these as two-story, you know, buildings, you'd be looking at something like 1,600 square feet for the single without counting the basement. And we're looking at 1,400 for the semi-detached, which is, you know, hopefully more attainable and by just providing more housing in this neighborhood. Thirdly, the reduction of the lot area, I guess, again, is in order to build these two semi-detached homes. So the size of both the semis is suitable for this evolving or urban neighborhood, in our opinion. And if you look at the precedents that we've attached in this package, I believe that's the last 2 pages. That's A9 and A10. You'll see that, you know, similar homes have been built in this neighborhood. And we think that we've made kind of suitable compromises in order to justify the fact that the lot width will be, and the lot area, sorry, will be reduced a little bit. Finally, for the fourth variance we're requesting, that's the rear yard setback. I'm showing here from 3.96 to 3.35, but I think after speaking to Mr. Nadeau, we are actually not even required 3.96, it's around 3.8, so I'll ask him to kind of butt in to clarify the exact number, but what we're proposing will be kind of under 2 feet or 600 mils for the rear yard. And again, a lot of these setbacks are due to the fact that we've reoriented the lot, and we find that we're still you know, maintaining rear yards, so green space for these people. The buildings are meant to be attainable, and we think they're suitable, but even then we're still a little bit tight on some of the areas around the site. So and again, the height is because it's a fairly minor height variance, under a meter, I believe, and we're giving ourselves a little bit of leeway based on just the working drawings for these haven't been done, and sometimes the structure varies a little bit. So just in order to make the building a little bit higher if need be, in order to accommodate the 3 stories on the kind of tight lot, we think that it's actually very beneficial for the neighborhood. Our firm, Home and Architecture, has as its core value a community, and you know, we designed by those principles, and I think by adding kind of well-designed you know, smaller units that are a little bit more compact, we add a little bit of height in order to still give the both the semis as well as the single a nice generous backyard. And yeah, I think that kind of concludes it. I think even we're talked to the planning department kind of closely, and just, you know, without taking the words out of their mouth, just reading kind of what they wrote in the letter here, they think that if small lot residential infill is to be pursued in Ottawa, this proposal represents an example of how it might be done attractively. So I think that speaks a lot to the quality of these architectures and to show that these variances are minor.
Thank you. Could we see the elevations for this project again, please?
So as you can see here, that's right, those are the 3D renderings. So we have a garage that's orientated towards Quill Avenue, and then on the single we have a kind of front door that's orientated towards Glen Avenue, as well as a nice corner feature window to animate kind of both those streets. So we have living areas, if you look at the plan, that that face towards Glen Avenue and towards, you know, in the same vein towards Glen Avenue. And then the semis are purely looking on to Quill Avenue.
We have do we have the elevations for the rear of those two properties?
Yes, I think we're looking at the same. Yeah, these are the new elevations that that we're showing. So we have kind of a living room, dining room situation at the back there with a door heading out to a stair that goes out to a back at grade patio. And that was the subject of the adjournment 2 weeks ago, was just because I think we were showing a rear yard balcony without thinking that it wasn't complying. But after some discussions with Mr. Nadeau, we realized that we can make it work in an alternative way by having an at-grade patio. And actually, I think it's a more suitable condition and will probably appease some of the privacy concerns if there were any of the rear neighbors. But again, these are backing onto a laneway and a garage to the property to the east of them. So I don't think privacy would even be a concern in the first place. But nonetheless, it's something to consider if ever.
Have you actually talked to the neighbors?
We haven't talked to the neighbors to the side, no, but I don't believe we've had any opposition from them.
And have you talked to the community association about this application at all?
Again, no, but they have raised some small concerns that we would like to touch base, and if there's anything we can do to kind of appease their concerns, we'd be happy to collaborate with them on this.
And just out of curiosity, why would you consider not consider talking to either the local community association or the immediately abutting and adjacent neighbors about your project in advance of this hearing?
We talked to planning and we got a really good response from them. Clearly,
anybody in the planning department going to live on that street?
No, you're absolutely right that it's a valid concern.
I mean, we suggest to all applicants that they talk to the neighbors and then they talk to the local community association if one exists. And your firm's been doing this for an awfully long time. And I think you know what you should be doing. Anyway, that's beside the point. Okay. Let's, any questions from the members regarding this application and or concerns? Mr. Wildman first.
Is there a street view image of the last one that we saw with the next existing unit beside it?
I'm not sure I understand your question with the new development.
Yeah, if
north?
we could put that last image up just for a second. So if we were to go a little further to the right.
That's right. So there is, I believe, a rendering showing a massing of the building to the north, and you'll see that the setbacks and the massing of the building is very similar. Although theirs would probably be considered 2 stories, it's actually a 2-story that's quite high out of the ground. So the massing is actually very similar in height.
That's what so that's what I was hoping to see. Do we have something?
Yeah, so maybe this view, I believe, shows it a little bit. And then if you look at the aerial view, I believe you'll be able to to kind of see the massing on the left, which is again oriented towards Quill, and the massing of the building is very similar in nature to what we're proposing. And
So how
the
much
setbacks.
lower? Like, because I realize the street is climbing in that direction, correct?
That's right. And so we're probably around a meter is what we're asking, is just to be able to make this fit under into a 3-story envelope. As we've talked to planning, I think they find it a little bit more undesirable to actually make it a sunken 2-story with and it makes it more difficult to service the garages with reverse grade driveways, which are I believe more undesirable from a kind of a servicing point of view. So, and it would require larger window wells if we're going to bring light into this. So in order to we're building at grade, and the garage is kind of at grade as much as we can. So that's why we require the extra meter.
Okay, thank you.
Mr. Wilder? You're muted, Mr. Wilder.
Sorry. You heard from the planner that there were some comments made. I really wish you would have met with the community association, because as Mr. Nadeau was mentioned, there were some suggestions made that I would have liked to have seen changes made to this, because of the fact that you have a very, very, again, small front yard. A lot of it is, you're looking at asphalt there for your walk, a little planting box. But, I mean, I've seen those in front of homes in other neighborhoods, basically. And, it just doesn't make up for the fact that as I drove down the street at other homes there, you're, giving up a lot. They're suggesting that the 2 walks near the entrances to the semis each turn, then join each driveway for access to the street. I would have hoped that you would have had a chance to meet with them to address some of the suggestions that they made, which you obviously haven't taken the time to do. A little disappointed about that as well. Also, yes, this fits with the neighborhood, and I've seen what else is being built there, but it comes back to the issue as well as of affordability. Have you any idea, again, what price range these homes are going for or will be going for?
No, I can't speak to the exact price, but again, just based on the fact, like the purchase price of the lot, by putting semi-detached homes, just their typology is more accessible than, single family homes. So if the lot were to remain unsevered and we could only build a single family detached home, it would by nature be slightly more expensive. So again, I think it's the nature of the neighborhood and the typology makes it that it's, these aren't going to be.
I appreciate that, of course, but your client, of course, could have built, a larger semi, providing more landscaping, more open space. You're obviously trying to squeeze a fairly large single, even with the parking garage, and then the semis next to them. On a similar size lot, I've seen people put in larger semis, just 2 units, better fit for the neighborhood, more green space.
So that's a valid point, but just to counter that, we believe that this lot was too big for being a corner lot. It was too big for 2 semis, and there's still, a cost of construction, cost per square foot. So if we were to build these kind of massively oversized semis, I think that those would probably be fairly more expensive than, being split up into 3 different units.
Thank you.
Any other comments from committee on this?
Mr. Chair, if I could just get clarification on whether we're dealing with a rear yard variance. And then the agent indicated that there were other addresses of properties that face onto Quill. So other than the one to the north, can you just tell me what addresses, the other addresses are that face onto Quill?
Yes, so 217 Glynn Avenue, which is now under construction as semis, or I'm not sure of the exact typology, but this is a new build, is now facing onto Quill. The property at 6 Quill Street faces onto Quill. Again, the property that's directly adjacent, which is 6 and 7, or 7 and 9, sorry, I'm reading that upside down, face onto Quill. And then the properties at 3 and 4 Quill, which are a little bit further north, also face onto Quill. If we look south of our the subject property, the 224 Quill, which is a house that is also facing onto Quill with kind of an empty parcel at the corner. And then obviously the community center, which is a little bit further south of that, also has kind of a front facing onto Quill. So generally we think that's the condition that exists at the moment.
So all these that you mentioned have their front doors, excuse me, their front doors face Quill.
That's correct.
And then can you also tell me, are there any, excuse me again, any other corner lots that have this type of density, like 3 units on it, or?
So the one at the corner, which is 217 Quill, with what is being built, has a very similar density. 224 Quill, which is directly south of our project, currently doesn't have that density, but just we could always assume that the house that's built further to the south on the lot will plan to subdivide at some point and build a structure on the corner there, because it's if you look at Google Maps or GeoAuto, it's just a new construction kind of deep into the lot, and it leaves a large portion of the lot open there as green space. And again, if you look at the context map that I added here, or sorry, at the page A10 for local precedents, as well as A9, you see that there are 97 Queen Mary is a corner lot with a similar density, and is very close to the to this project.
So just my last question then, the property that you mentioned across the street at 217, is it, I'm just not familiar with it. Is it a semi-detached or?
To be honest, I am not sure of the exact construction going on, if it's a triplex or if it's a 3 townhomes side by side, or if it's a semi-detached. It's a building under construction, and I think it was just coming out of the ground in the past few weeks. So I'm not sure exactly what was proposed there.
Okay, thank you.
Thank you, members. Thank you, Mr. Luttrell. You're aware of the planning department's conditions?
Yeah. Yes.
Blue, independent services, joint use and maintenance agreement, services capped, grading and drainage, accessory structure removed or relocated, and a convey a 3 by 3 meter corner side triangle to the city. Okay. I think what we'll do is we'll reserve on this application.
Mr. Clarification on the rear yard, is that still a variance or not a variance?
So the rear yard just on the, oh, sorry, that was for Mr. Nadeau.
It doesn't matter. You sort of were vague on whether that rear yard had to be changed, and you were asking the planner.
I can clarify through the chair. Initially, and I believe this came up during my review and initial discussions with Mr. Latreille during the prior to our first hearing, there had been the question of whether a yard area variance was needed, just owing to some lack of clarity in the drawings at hand. It turns out that they are compliant on that front, owing to the fact that while they are seeking a rear yard variance, it's for a portion of the building that's cantilevered above the yard to a relatively shallow degree, and thus at grade we do have a sufficient yard. Relative to the setback requirements, they are asking for a 3.35 meter setback. That remains the case. I think the inconsistency had been where the applicant had identified a bylaw requirement of 3.96 meters. By my review, under section 159, subsection 9.1, they would need a 25% of lot depth, which would be 3.8 meters. So in fact, the extent of the variance being requested is less than the applicant might have indicated at first.
We should amend our notice, therefore, to read for D, permit a reduced rear yard setback of 3.35, whereas the bylaw requires a minimum rear yard setback of 3.8 meters.
Thank you.
That all right with you, Ms. McLean? That satisfy you?
Yes, thank you, Mr. Chair.
So we wrote off the conditions. Thank you for your presentation. We'll reserve on this application, and you'll hear from us in 10 days.
Perfect. Thank you very much. Have a good afternoon.
Okay, you too. And that concludes the agenda for the 4th of November, 2020. We are now adjourned.